Julie Paquette, probate and estate planning attorney, and today I want to talk about the costs of waiting. And in this context, I'm talking about in the administration stage of an estate. I talk a lot in my videos about the cost of waiting if you don't get your estate planning done, but today I want to talk about the cost of waiting to seek counsel when you are the beneficiary of an estate. So there's three key points I want to make today about the cost of waiting. And the scenario I'm thinking about is when you are involved in a case, either a trust or a probate estate, where you are the beneficiary and maybe it's a family member who's in charge of things. You may refer to them as the executor, but they might be the trustee or the personal representative, and you're suspecting or you're quite sure that your rights are being impaired. You're not getting what you're supposed to get out of this estate, or the trustee or personal representative is not administering the estate correctly. And of course, we understand you wait. You don't want to go seek counsel because you want to give the benefit of the doubt to your family member, or you don't want to create additional family strife by seeming like you're trying to create conflict, or like you're lawsuit happy, you're ready to drag your family into court. So we understand all those feelings. And of course, there are family dynamics involved. Sometimes there's a lot of family history that's bubbling up to the surface. Now, maybe the last surviving parent has passed on, and a lot of issues are coming up. So we get it. We understand the reasons of why you may hesitate to seek the assistance of an attorney. But we have cases where people come to us and it's just, an individual's breaking point, how long someone will put up with things before they come to us and say, hey, I think my rights are being impaired and now I think I'm ready to do something about it. And we've handled matters for clients that waited, a few years to 5 years, 12 years, almost 20 years. Some trusts go on for a very long time. And so the first thing I want to say is that the longer you wait, the more damage can be done. And sometimes that damage is not reversible. So especially in a case where there's a lot of different assets, real estate involved, businesses, sometimes these assets just, the damage can't be reversed. As time goes on, there are losses involved. And depending on what everyone is entitled to out of the estate, you may not be able to get your full share back. So waiting longer can create further damage, can create irreparable damage. And another issue is that an argument can be made against you that by waiting so long, you have sort of ratified this bad behavior. You've gone along with it. You haven't spoken up. And especially when we're talking about several years have gone by, the other side may say, you know what, you were aware of this, you had notice of this, and you agreed to it, or you participated in some of this and you didn't complain. So that kind of hurts your case. If you've sat around and didn't take action, you can't just sit on your hands and wait for bad behavior to go on, and then at the end say, you know what, I have a problem with this. So it's very important to speak up quickly. And finally, judges are notorious for giving people a chance. So if you do get to your breaking point and you go seek an attorney, you may be frustrated with how slowly you are able to assert your rights. So first of all, you've heard me talk about, how slow the court process can be, which some of that is necessary to be fair to everyone. For instance, you've got to get on the schedule at the court, and their schedules are very full. So by the time you file something, you could be getting a date set many weeks, even several months out. Especially right now, dockets are very backlogged. So sometimes we get a court date that's set 4 months out in the future, and that could be very frustrating. You also have to have a notice period. You've got to have time to give sufficient notice to the parties who are involved. But then judges, very rarely will they make a decision at that first hearing. So you're coming to the court saying, here's all my evidence, here's my petition that the trustee is not acting correctly, here's all the things that they've done wrong, and I want them removed now, please, and put me in charge or put someone else in charge so we can get this all straightened out. Almost every single time, the judge is going to give the trustee, 30 days or 90 days, maybe even more, to rectify things, produce documents, show that no, because of course they're going to come in and argue, no, I have been handling things correctly, or okay, I've made some errors, but they were inadvertent, or they weren't a big deal. And the judge is going to give that person time to come forward and show that they haven't done anything improper, or give them a chance to start doing it right. So, that can be very frustrating when you come in and it seems like the court agrees with you that they have not been doing things correctly up until now, but from now forward, if they do things correctly, they can remain in place. So that can be pretty frustrating. So, for those reasons, and there are more reasons as well, of course, but those 3 key reasons, I would like people to understand you really shouldn't wait around until your rights basically have been trampled on to at least consult with an attorney. And keep in mind, as a beneficiary, you have the right to have counsel advising you as to what your rights are, just like the trustee or personal representative really should have an attorney helping them, advising them, letting them know what their duties are, what their rights are, what they've got to provide to the beneficiaries. A beneficiary is entitled to have counsel, and that does not suggest that they're making any kind of accusations against the trustee or anything like that, just to have someone advising them. And, we can certainly advise people as to what your rights are without bringing a dispute to the court. We can just be there to help explain how things work, what you're supposed to receive, or if you're receiving things from the trustee, why are you receiving that information, or what should you do in response to receiving information. So at least consult with someone. You can find out how the relationship works when you have an attorney on your side, what the costs are. And then, of course, if you're already working with an attorney, if things should go awry, they're already in place. There's not going to be a lapse in time for them to catch up, get up to speed with what's going on. You have to go to the court, get a copy of the file to try to patch together everything that's happened. Your attorney will already be well informed. So if you have any questions about this, please give us a call. We'd be happy to set up a consultation with you and go over it all. Thank you.